This is the second panel on law and the state and the role of transitional justice for stability and democracy in European countries. Now, the role of the chairman is mostly, it's an inflated name. I think I'm basically the timekeeper here. So I will refrain from making any extensive remarks. Let me just maybe say something just to begin the conversation, and that is that, of course, the more you have to rethink about the past, the more difficult it is to think that legal processes can play a very important role. Law is essentially emerging, efficient, very good when it acts on the margin. When people follow a certain norm by themselves or because of their interests or because of various institutions, then enforcement of those few cases in which the law is broken on the margin is actually very effective. On the other hand, if certain norms are ignored by a very large number of people, enforcement really makes very little difference. And from this point of view, you would expect that the role of law in rethinking the past after the fall of communism would be very different depending on which country we are talking about. To go from, to move away from Eastern Europe for a second, after World War II, Britain had a very simple job of transitional justice. It had a couple people whom it treated actually very severely as traitor, William Joyce, basically the consensus of what the national identity means and so on was never in any way broken. So there was very little to settle after the war about it. On the other hand, the French had a tremendous amount of work to do, as did, of course, the Germans. And the process was, of course, much more complicated, and law played a very difficult, ambiguous role. That is, it extracted a serious amount of revenge right after the war, but really did not lead to any genuine reconciliation. What led to reconciliation was basically forgetting about it and de Gaulle's re-establishing a certain kind of fictitious picture of history. Now, one would think that Poland, of all places, would be one of the least controversial, would actually be one in which transitional justice would not be a very difficult issue, because the distinguishing characteristic of Poland was that the system was in some way very weakly legitimized. That is, the communist system had been in some ways very weakly legitimized and did not penetrate very deeply. Of course, it penetrated in sort of daily shortages and other things, but in terms of ideology, in terms of somehow the self-identity of Poles and their picture of history, there persisted a rather widespread consensus. And then it turned out, after all, that rethinking the past became extremely controversial, in part because the discussion, I think, was not really about communism. Communism was used as that one part about which there was consensus, and tagging a certain kind of label of communism collaboration was a way in which one could delegitimize various fragments of essentially oppositional activities. So much of the struggle about the past in Poland seems to be de facto a struggle about the presence and a very long past. That is, it's a very difficult job of a cultural war somehow about remaking the country, in which various important actors, most of whom were against communism to begin with, somehow are tagging each other with collaborationism in order to fight a completely different kind of war. And that somehow made the use of legal system frankly impossible. That is, you couldn't really take this huge job of remaking the past and fit it into some sort of legal process. So it became a much broader phenomenon. Anyway, that's just a remark that I wanted to make to begin with, because everyone here has much more to say and knows much more about these things than I do. So I will follow my predecessor, Timothy, in not repeating the introductions that are already included in the materials, and simply call on Eva Pettai to begin with.
Thank you very much, and thank you for having me here. I will actually straight away continue the conversation that we had in the previous panel, which is that I will present today some thoughts that me and my colleague, Bello Pettai, had by developing a framework for studying post-communist transitional justice. And we came from the realization, reviewing the literature, that, and I think it came out a little bit in the previous discussion as well, that despite the proliferation of literature on post-communist transitional justice, there is very little effort been made to fully conceptualize all the different areas in which a state can actually engage in truth and justice in this region, a strong focus being on lustration, and really have authors tried to more systematically show how the different areas of state engagement in these issues of truth and justice hang together. So we tried, what I will do in this paper is that I very briefly, because this has been published last year, and some of you know this model already, I will very briefly introduce some of the key components, but then go beyond this and show and discuss with you some of the observations that came up from this way of mapping truth and justice politics across the entire field on the different countries. And there I will put particular emphasis on the issue of time, which has come up already, and then also on the mode of institutionalization that we can observe in the region that is, I think, very significant for this region. Okay, so our understanding, our basic understanding with trying to map out the full range of truth and justice measures was that the different realms of truth and justice are somehow connected, and that it is important to examine them as a whole in order to identify emerging patterns in a state's approach to the crimes and wrongdoings of the past regime over time and across various domains, legal, administrative, and symbolic. And this is what we basically came up with straight away. So we, based on the literature, and I won't go too much into the genesis of this model, but based on the literature, we could differentiate very basically between measures that are addressed to perpetrators, that are retributive in character mostly, and those restorative measures addressed to victims, targeted at victims. But then we differentiated between three different domains: the criminal judicial, the political administrative, and the symbolic representational domains. And by doing and developing this kind of 3x2 matrix, we realized that indeed each of these boxes can be easily filled with concrete state measures, as you can see here. Without going any further into the details about this model, let me just highlight two key points. First, organizing and relating existing state measures in this way helps us to better identify processes of interaction across the matrix, thus showing how the politics in one sphere of justice may be closely connected with policy development in another. Second, the matrix allows us to distinguish more precisely between sanctions that involve administrative procedures, especially in this field, that is sort of what we heard before, that is framed in lustration terms, the purging and vetting and the self-reporting. And so here we can actually distinguish between those that do not involve actual state regulative power very much, that are mostly symbolic, as we call them, and those that actually have real consequences in terms of sanctions in office bans and disqualifications. And thus they involve different levels of political costs, if you want, and different political dynamics. A look into the specific post-communist experience made us realize, however, that this is not yet it, that we have to actually factor in two temporalities, as we call them, two time dimensions that are involved in post-communist transitional justice, and that have to be added to this simple model. Often the crimes that require adjudication or other ways of addressing in one or the other way had been committed many decades earlier. And this is something that is, of course, due to the historical trajectory of communist rule, but that needs to be acknowledged because the politics involved in implementing measures that target wrongdoings 60 years earlier or 50 years earlier are quite different from those targeting the outgoing elite, for example. Thus, we try to factor this in, and what we realize is that we have to double our boxes in the sense that there is a retrospective and a transitional dimension to post-communist truth and justice politics. Thus, the retrospective targeting wrongdoings, adjudicating and redressing wrongdoings that happened many decades earlier, transitional, more concerned with the more immediate outgoing regime. Again, there are different politics that are involved. I will come back to that. But then there's another time dimension, and that's what we had in the previous discussion, that also needs to be accounted for in mapping out the entire politics of truth and justice. And it starts from the moment of regime change and involves the processes by which transitional justice measures are adapted, implemented, and amended over the following years and decades. This way of temporal tracing of the truth and justice politics then also captures a phenomenon quite widespread across Central and Eastern Europe, namely the later day revision or new introduction of measures long after the actual transition is over. In order to account for the most substantial later day revisions of previous settlements, such as late Lustration laws, for example, and narratives, we adopted a slightly refined term, and refined the term introduced by Kath Collins and Filippo Raimundo, that of post-transitional justice. And in fact, in our holistic approach, the case of post-transitional justice, thus a later introduction of measures that substantially alter previous settlements and narratives, would need to affect several boxes at the same time. So that was our assumption, that we would probably see major changes, substantial changes in truth and justice measures across various boxes. In our application of the model to the three Baltic states, we marked policy changes and their quality on the second temporal dimension by way of using gray shades, and I will show you how the result in a moment. So to add some sort of a third dimension to the matrix and evolve into a landscape of truth and justice politics. And this then evolves, there you can then really see the emerging of patterns for particular country cases that you can then compare in order to come to a full-fledged typology of truth and justice in post-communism. And this is what it looked like in the Baltic cases. I now picked only two of them because they are sort of the most extreme in the comparison. And you can see how that then works when you have these 12 boxes and you indicate major changes, introduction of new laws and regulations, as well as institutions over time. You see a slight time scale on each of these boxes that shows that very nicely. I will not go into the details of this landscape of transitional justice in the Baltic states, but briefly, based on this small case study, we ended up developing a classification scheme that would use an ideal typical scale from no state involvement on the one hand to a strong state-led and etatist approach, so very strongly state-led approaches to truth and justice. As you can imagine, based on these two graphs, we classified Estonia as falling on a rather different position on that scale than Lithuania. We named Estonia the hands-off case and Lithuania the hands-on case. But now I would like to move to the 2 points that I actually take from these examples from the Baltic states, and that might be actually interesting to transfer or try to compare to the rest of Central and Eastern Europe, and as we have the experts here, we can discuss that perhaps later. My first discussion point is concerned with the retrospective dimension of post-communist transitional justice. In fact, I would claim that if we were to apply our model to other countries of Central Europe and the Balkans, we would see relatively more activities in the retrospective dimension of the matrix across the region compared to that of transitional justice. In the Baltic case, this is clearly so. You can see much darker shades in both cases on the retrospective side of things. Right from the beginning in 1990-91, the focus of Baltic legislators and policymakers was on providing the frameworks and mechanisms to adjudicate and acknowledge the distant crimes and mass atrocities of the Stalinist years between 40 and 53, rather than on targeting outgoing heads of the KGB or the local Communist Party or seeking redress for dissidents and other victims of the recent rights abuses. A review of existing data, and there's plenty of it available by now, in the region reveals that we are talking here, however, I think of a pattern that we find across the region, where those that pursued truth and justice invested considerably more resources in state regulatory power on adjudicating, investigating, and acknowledging crimes and abuses committed during the Stalinist years, the immediate post-war years in Central Europe, and then on those committed in more recent years. This is by no way surprising given the historical trajectories of communist rule, where the most horrendous crimes and human rights violations took place before, during, and shortly after World War II. Yet it had certain repercussions for the transitional justice processes that I think are worth mentioning and pointing out. Calling for retributive restorative justice vis-à-vis historical crimes involves different cost-benefit calculations and hence different political dynamics than going after people who might still be in power or want to return to power. But what's more, the motives behind pushing for retrospective justice are clearly less concerned with actual perpetrators and victims, and more, or with administrative reform and the locking in of democratic transition, and much more with moral appeal and identity-related issues. The relative dominance of the retrospective justice dimension in the post-communist world led to a situation in which early on questions of individually targeted accountability and redress, usually associated with justice measures, became deeply entangled with the politics of collective remembering and identity. In some way, all transitional justice involves mnemonic construction. However, engaging in narrative construction is usually... Okay, I have to rush then. Okay, so this deep entanglement of memory politics with issues of transitional justice that are usually individually targeted and look for individual perpetrators and to punish them or redress victims has become very quickly collectivized in the post-communist context, and it became an issue of national identity, how to deal with the past. But to what extent that explains the recurrence of the past in current politics, I would at this point leave for the discussion later, because I need to go to the second point I want to make, which is the mode of institutionalization. And here I turn to the other time dimension again. And if you look at the Lithuanian case in particular, you see the darkening of shades at around 96, which indicates that there was a major shift in transitional justice measures by the state by introducing a centralized agency, an institution, the Genocide and Resistance Research Center, under the roof of which activities, laws, and policies were implemented across the matrix. So you can really see the darkening at around that time. And what is remarkable about this is that changes in transitional justice politics often involve the introduction of a new institution and an institutional actor. And this is something, I think, again, that we can see some similarities across the region, that we have these strong institutional actors that combine transitional justice politics or implementation of policies under their roof, often multitasking in various areas, from lustration to memory work, to even working with the prosecutor general. The EPN in Poland is one example, but also the Institute for the Study of Totalitarian Regimes and the Remembrance Institute in Slovakia. Estonia, on the other hand, is very light, and this is partially also the case because Estonian policymakers did not establish any special and lasting institution to implement official justice measures. The furthest policymakers here went was to establish state-sponsored temporary commissions that would investigate crimes against humanity or Soviet-inflicted human and cultural and economic damages, but they were closed after they completed their work. And so it was with lustration measures, which were mostly declarative, symbolic. There was a deadline, and that was not extended. So there was no particular institution, there still to this day is no particular institution in Estonia that would actually implement truth and justice measures. That, in a way, reduced the number of actors competing for resources in the public sphere quite substantially, and that might explain the light shades and the actual whitening of boxes in the Estonian case, where you have almost a feeling of closure in this case. And that would be, to conclude my point here very, very rapidly, is there a link between the institutionalization that we observe in so many of these countries of transitional justice and memory politics through instituting or through establishing new institutional agents in the field? Is there a connection to the reoccurrence of debates and of transitional justice issues in the public sphere? And is the Estonian case, for example, where there's no such institution, is that an example of closure? Does that mean that they have more effectively dealt with these questions by never really establishing institutions, and institutions don't like to be dismantled, so they become this kind of memory warriors in many cases to push for more and to strengthen those who want to reintroduce policies and or strengthen them. That would be a question to discuss, as well as the general concluding observation that both of these issues, the retrospective dimension of transitional justice in the post-communist world, as well as the particular mode of institutionalizing memory and truth and justice measures in this region, marks it off from other transitional contexts, from my point of view, both post-World War II, Western European countries, as well as Latin American, where we do not see this kind of introduction of institutional actors and their strength over time and their warrior kind of emergence over time. But I end at this point, and
thank you very much.
Leave the rest of the discussion.
If I may ask, Valis, there's still the idea, I think, that 15 minutes is the absolute limit. But if you have a way of saying what you can say and saving a few minutes for discussion, that would be very good, because we are essentially behind in terms of time. So our next speaker is Kriszta Kovacs.
Yes, and I also have a PPT, so let me find that. It is a real honor for me to address such a distinguished audience here. Thank you, Carolina, for having me here. I'm a constitutional lawyer, and I'm involved in a joint research project with Gábor Attila Tóth, which aims to compare the recent constitutional developments in Hungary and Poland. Now, in Hungary and Poland, the question of how to settle the past was first raised in 1989, and recently this question has been brought up again as part of both countries' turn towards authoritarian rule. In this presentation, I take a quick look at the constitutions of the Third Republics of Hungary and Poland, and then I make a comparison between the recent Hungarian and Polish legal frames of memory. Finally, I plan to go beyond my professional field to show some examples of how history is present in the current politics of Hungary and Poland. So let me start with a brief overview of the constitutions of the Third Republics. In 1989, in both countries, roundtable negotiations led to democratic regimes. In the aftermath of the Polish roundtable talks, two major reforms of the old constitution had been carried out, the amendments in 1989 and the so-called small constitution in 1992. And this reformed constitution was replaced in 1997 by a completely new constitution which made the democratic transformation complete in Poland. Now, in Hungary, the 1989 constitutional revision was only an amendment. The constitution formally remained the Act of 1949. In material terms, however, it was a constitutionalist constitution. In 1997, an attempt to bring the post-communist constitution-making process to a conclusion was failed. What we have now is a constitution adopted in 2011 with the votes of only the governing coalition. In what follows, I would like to compare the historical references of the two constitutions, the 2011 Hungarian and the 1997 Polish. First, let me say a few words on the recent Hungarian development. In 2010, the Hungarian Third Republic collapsed. Failures of the then government and social tensions undermined the legitimacy of the democratic regime. A deep financial, political, and moral crisis made fundamental changes appealing. Therefore, in 2010, when the current governing coalition gained a constitutional majority, it opened the way for a profound change of direction. As the first step towards a brand new regime, the ruling coalition adopted the proclamation of a statement of national cooperation. Here you can see excerpts from the text. According to this proclamation, the identity expressed by the 1989 constitution failed to comply with the Hungarian national identity. Furthermore, those in power argued that the period of post-communist transformation should draw to a close, and for this reason Hungary needed a new constitution which was able to provide, and here I quote, a foundation for the spiritual and intellectual renewal of Hungary. Consequently, in 2011, a new constitution was enacted. Surprisingly, the constitution makers in Hungary referred to the 1997 Polish constitution as a role model. However, the texts of the two documents and the traditions they follow differ significantly, and the two constitutions have different approaches towards the past. The Polish constitution follows the republican tradition of the country. Its historical narrative represents a reflective and critical view by stating that the country that recovered in 1989 is mindful of the bitter experiences of the times when fundamental freedoms and human rights were violated. By contrast, the Hungarian constitution doesn't even mention the republican traditions or look back on the tragic failures of the nation. In its concept, 1989 was a beginning of confusion, and the real revolutionary year was 2010 because of the landslide victory of the governing party. The historical references negate the post-Second World War, the communist and also the post-communist eras, including 1989, by declaring that the country had lost its autonomy in 1944, and this autonomy was restored only in 1990 with the opening session of the first freely elected National Assembly. So the official state policy is that Hungary lost its sovereignty because foreign troops had entered its soil and remained until 1990. In this narrative, the symbol of Hungary's sovereignty is the Holy Crown. You see references here, allegedly of St. Stephen, Hungary's first Christian king's crown. And historically, this crown was seen as the bearer of the so-called historic constitution of the Hungarian kingdom traced back to the Middle Ages. You remember Jan Kubik's picture of the Greater Hungary, so this is what I'm talking about. The new constitution claims continuity with this historic constitution, and even the name of the constitution, fundamental law, implies that it is not the constitution but only a part of the Hungarian historic constitution. So the fundamental law was not adopted in the spirit of the Velvet Revolutions like the Polish one. On the contrary, the document turned against that tradition. Now, what we read in the fundamental law, we can find in the 2011 program of the Law and Justice Party, the Peace Party. In 2011, Jaroslav Kaczynski announced that he wanted to create Budapest in Warsaw. The party's program called for change of the political system. One of its paragraphs outlined that the state must be understood as a moral quality having strong ethical foundation, which requires both a fair verdict on the communist past and purification of the social life from the 1989 system. One can find many similarities in the Hungarian fundamental law and the Peace Party's program. The most likely explanation to that might be that the two countries' leading political forces share the same politics of memory policy. But what kind of ideology serves as a basis for this policy? Adam Michnik argues in his book The Trouble with History that historical narratives are replaced by ideological agenda and sense of victimization. Many Poles believe that the country's historical foundation lies in heroic fights against the Asian Bolsheviks and the German hordes during the Second World War. They cannot forgive either of these two traditional enemies. Similarly, according to the prevailing Hungarian ideology, the country was a victim of the occupying foreign forces. This ideology, based on partial truth, depicted Hungarians as victims, stripped of two-thirds of their lands after the First World War, then occupied by Germany, Nazi Germany, towards the end of the Second World War, and after the war by the Soviets. In today's Hungary, everything that is anti-communist is praised. The Constitution asserts that the society's sense of justice shall be ensured by making possible the retroactive prosecution of politically motivated crimes committed but not prosecuted during the communist regime. And this anti-communism goes hand in hand with coded anti-Semitism and not so coded anti-liberalism. So we find similar historical misconceptions in the legacy of the democratic opposition in Hungary and the solidarity in Poland. The fundamental law denies the historic role of the opposition movement, while the peace, to say the least, keeps distance from the solidarity that compromised with the communists. There are many similar misbeliefs in Hungary and Poland, but we should, of course, bear in mind the differences. For instance, the roles of Poland and Hungary were far from similar during the Second World War. Although none of them were merely victims of the Nazi aggression, the former was attacked by Hitler and the latter was an ally of Hitler. In the last part of my presentation, I tried to show how the new politics of memory works in practice. In order to put history at the service of politics, museums were set up or taken over by the governing majority in Hungary. The first is the House of Terror, is the realization of this official state policy, which makes one terror regime, the Nazi, almost taboo, while demonizing the other, the communist regime. In this museum, only one room out of dozens is dedicated to the Hungarian Holocaust, and it's more than 500,000 victims. As I mentioned earlier, the historical narrative of the fundamental law denies that the Hungarian state played a decisive role in the tragedy of the Hungarian Jews. In accordance with that, exhibits and memorials show the events that took place after the German occupation of Hungary, but not the road to the Holocaust. It is also true to the controversial memorial which was erected to all the victims of the German occupation of Hungary. The memorial, composed of a tympanum with a bronze eagle representing Nazi Germany. Below the imperial eagle was erected a bronze statue of the Archangel Gabriel, representing innocent Hungary, holding an orb representing the power of the state. One of the eagle's talons is tagged with 1944, the year of the invasion. Because of the heavy protest, the government erected this memorial under the cover of darkness. Since then, the protest has evolved into a living memorial. It is not made of bronze and stone, but of the present thoughts, conversations of the citizens who now gather at Szabadság, means Liberty Square, every evening. People also brought stones, candles, photos, personal belongings that express their feelings and place them in front of the official memorial. Now, many steps the piece has been taking recently look familiar to those who followed the Hungarian steps. Joanna also showed the picture, and if I'm not mistaken, Norman Davies mentioned yesterday the case that a decision was made lately to cancel the project of the Museum of the Second World War and to merge it with the Museum of Westerplatte and the War of the 1939 in Gdańsk. The government justified this move by saying that the new museum would not express the Polish point of view. More specifically, they communicated that the institution shall talk about the history, taking into account consideration the tragedy of the Polish experience, predominantly by means of, and here I quote, emphasizing the fact that the biggest conflict in modern history began with the German invasion of Poland. And here the quote ends. The founding director of the museum in his announcement emphasized the fear that the museum will be a subject to the current political need. Now, to wrap it up, many analysts agree that the recent Polish legal and political changes are close to the post-2010 Hungarian transformation. Both political systems highlight the need to have a sovereign state based on traditional values and national interest. However, the Hungarian regime has already produced a new undemocratic constitution. And although the idea of adopting a new constitution has been raised recently in Poland, the piece is not in the position to easily replace the whole 1997 constitution, which is a product of the Third Republic. The difference between the two current constitutions is that under the Polish, settling the past by assuming responsibility for the grievances done is not impossible. By contrast, the ideology of the fundamental law is based upon the mythologization of historical facts, which makes reconciling with the past impossible. Despite this difference, the similarity in between the Polish and Hungarian politics is remarkable. Both ruling parties prescribe required interpretation of historical events when enacting laws and taking controls of museums. The motivation of these steps is mostly the political revenge. The new politics of memory policy is being used to settle scores with political rivals. So let me finish by saying that it seems that both countries still have to wait for coming to terms with the past in a way which makes social catharsis possible. Thank you.
We therefore move to Adam Czarnota.
Thank you very much. The organizers and the chairman, they invite me to shorten my talk. Therefore, I will only sketch with a broad brush general issues which interest me actually in relation to the TJ, Transitional Justice. Right? When I put here the topic, when I was asked about the topic of my talk, I thought about it and I wrote 3 different abstracts and I threw them out. Right? Why? Because I got a problem actually on which one to focus. But what interests me the most is the use of transitional justice as a constitutive process in 2 senses. In one sense, as a constitutive process for the new polities, it means the creation of the new polity. Then the second one is as a constitutive process for the new law, which is before us. What I mean, the first probably is easy to say, easy to explain. Then, so I will start with the second one. It means transitional justice as a not discipline, but as an area of study is growing. Right? A few years ago, here in Oxford, there was a conference organized in the Socio-Legal Studies Department Center on Transitional Justice, and it was about 1,000 people. Thanks to God, not all of them were lawyers only, but plenty of different Africanists, specialists in Asia, and so on. And there was no common discourse, not at all, which shows basically there is no theoretical background. So in more than 20 years, when Ruti published her famous book, Transitional Justice, till today, what we observe is plenty of case studies of the Rwanda or Serbia, Bosnia, but there is no one common, even there are some more now articles which try to conceptualize basically this empirical material. And it seems to me that there is some reason. I don't look for the secret vision there, but there is one reason why it's so difficult to create, to conceptualize this really huge now empirical material. Why? Because one of the elements, which I agree here, with the thesis that transitional justice is a part of liberal discourse, but the institutions created as outcome of this discourse lead us to that non-liberal concept of law, which is extremely dangerous, and all those new quasi-judicial institutions, they simply destroy something which was traditionally connected with the individual allocation of guilt, responsibility, accountability, and so on. So then it seems to me we could treat these transitional justice processes, a global one now, as this constitutive element for the maybe liberal. I don't like this post because everything is post, right? But I don't know the expression, which is something new. There's some new model of law which is taking over, it seems to me, and replacing this liberal part of law. And then let's go to the first one, which seems to me that transitional justice, or dealing with the past more in this region, as a constitutive constitutive element for the politics. Well, there is a paradox which my two colleagues nicely express before me, that more and more time passed since breakthrough, since 1989, there is a more and more dealing, or legal dealing, with the difficult past. So if we try to look at this question, the law, it seems to me, is not a very good instrument to deal, actually, not to solve the problems, and even to explain the problem. What is necessary, probably, is some sort of the sociological attitude approach, or at least socio-legal attitude approach. And probably the guy who, well, the person, sorry, guy, for not for this language, the person who is a starting point for all studies on memory is Holzbach. And what Holzbach wrote precisely is that discussion about the past, they start from the present, which means there is a political struggle in the present determine the vision of the past. Not that past dictates something which dictate the present only. There is a sort of the dialectic connected with one another. And then it means, if we accept that, then probably the next step in reasoning is such that there is some moment, not constitutive moment, as the constitutionalists try to tell us, but moment which is good one, or the best one, the window of opportunity to settle down in the optimal way the problems with the past, not by imposing some narrative, but by creation of the institutions to cope with the potential problems. If this moment passes, then it's necessary to wait for the much longer time. So what are the most important elements before the dealing with the past? It means before maybe on the beginning of breakthrough. The first is a character of the political settlement, character of the situation when the political breakthrough is taking place. And then the element of social capital, which exists in the particular society. So let's say situation in Rwanda will be totally different, right, than the situation in Kosovo, Bosnia-Herzegovina, or in Poland. But what unify all these approaches to transitional justice is a need for the setting up some mechanism, institutional setting, for the creation of the new normativity. So where from this normativity is one option is to impose from above. It means, well, but it doesn't work. So it means, can we imagine through the institutional design to set up some institutional structure which will actually generate this new normativity based on what? That's actually is a global discourse. Human rights, dignity, and observance of rule of law. Doesn't matter how we understand rule of law, right? It means where from? What is the source? It means how to generate that. And a necessary precondition, necessary element for this creation of normativity is precisely some elements of dealing with the past in the institutional, let me repeat, way. Not manipulation with the past. There's a fantastic book written by István Ref, right, from Budapest, which shows precisely this manipulation with the past and where it is leading us. So now the crucial issue for law, nobody is perfect, I'm a lawyer, right? So what is this crucial issue? It seems to me was mentioned in the former panel. It means relation between the law and politics. It means transitional justice is based on the finding up this optimal relation between law and politics. Normal attitudes within the Western legal tradition is, the liberal one, is based on what? Recognition of the autonomous character of the legal system, which means there is no authority which is able to impose something. But such system could be created too early. I mean, it can't simply appear as those ex machina, right? So I mean, this problem of relation between law and politics, it seems to me, is crucial to all our discussion, could unify all those problems of transitional justice. And it is not something new. It means in the social theory, that's always been the discussion between the, let's say, value rationality versus instrumental rationality, which has to be present in the legal system. But the paradox in transformation, because I don't like transition, is such that in transformation, law is an instrument to achieve some aims, at the same time supposed to be quasi or semi-autonomous. How to achieve that? And actually, how to achieve is one question, and the second question is who is going to implement that? In the legal philosophy, there is a paradox of hanging judges, so-called, right? David Eisenhower, one of our colleagues from Toronto, he described it in the case of South Africa, that, well, judges use law. And they knew even that this law is brutal, is outside justice. Nevertheless, they use it. Means now, after the change, can the same people really be responsible or the social source as a legal profession for the new normativity? Well, it's possible to have some doubts. And then what I wanted to say, I've got 3 minutes left, right?
No, you have a little
5.
more.
Okay, so 5, better even. So now what is left is I strongly oppose to reduction of transitional justice to only the problem of the gross violation of human rights. It seems to me the most important element actually is not only gross violation of human rights, but redistribution of property rights. And it is most visible, especially under post-communist transformation, but not only. In each authoritarian regime, there was a transfer of political position to economical rent. It means there is one of the very talented anthropologists, Mahmoud Mamdani, right? And what he wrote in critique to the TRC was a critique of term of reference of TRC. That what's happening in South Africa was no mentioning of the source of apartheid, which means stealing of land, right? So that, it seems to me, has to be taken into account. That it's not that transitional justice always is some proportion, some balance between the retributive justice and restorative justice, victim offender's point of view. But property, I mean, the redistribution of property rights has to be counted not only with the victim's issue and the perpetrator's issue, but with the setting up precisely this base for the new type of polity. How to do it, I don't know. But that's a problem which is necessary to simply consider. And now, outcome of that is something which, outcome of this transitional justice processes, all those institutional innovations, right? They are the most well-known, so it means truth commissions. I remember I read your essay, right, about the Bundestag Commission, which is only one truth commission here in Europe. But these all others, there's a motive, it means innovation in the peculiar way. So let's say truth commission, truth reconciliation and welcoming commission in Timor-Leste is something different and operate differently than, let's say, truth commission in Sierra Leone. But they are institutional innovations, or let's say Gacaca courts in Rwanda. That was using the old name, but giving like the old bottle with new wine inside. And then hybrid courts, we have to remember, right? Hybrid courts based on the acceptance of foreign judges or creation of the special chambers, like, let's say, in Bosnia-Herzegovina or in Cambodia nowadays. And universal jurisdiction, that's also mechanism which is maybe independent partly, but it developed in the same time with the discourse of transitional justice. So then law itself, I try to now conclude quickly, is a system of systematic remembering and forgetting. I mean, law in Western legal tradition over a few thousand years developed this is a system. It means law could impose forgetting as well. After 25 years, statute of limitations, we have to forget something. It does not mean it is a social forgetting, but it's a legal forgetting as such. But law is limited in dealing with a very complex issue for two reasons, it seems to me. One reason is that legal system, modern legal system, is based on some fictitious assumptions, like, let's say, legal personality. What is it, right? And then legal personality, and then the second, what was probably put in the best way by Niklas Luhmann, that is an open system, is cognitively open but operationally closed, which means each information which the system swallows is transformed into according its own logic. And the outcome of this logic is something which is not necessarily accepted by normal citizens. So I could give you only one example. That I remember speaking in Australia to one of my friends, and he is a historian of Second World War, was asked in the first trial in Adelaide by the judge there. So was possible to have this or that type of uniforms by the Ukrainian police? And his answer was, yeah, depends. And the judge said, yes or no, which means law imposed only black and white vision is as simplistic as such. And the last part, it seems to me, is that complicated problem of the relation between the law and politics. That, unfortunately, probably, at the moment, in the liberal constitutional democracies, the public sphere is basically reduced to law, which means the virtues are coming from the legal system there. That should be changed. And it changed in order to what? To defend, basically, the liberal character of constitutional democracies. And, I only want to finish that law is a limited tool, and not very good, to deal with a complex problem of the past. And the outcome is something which was probably nicely formulated coined by one of the dissidents from DDR, that we fought for justice, we got rule of law. Thank you very much.
So we move to our last speaker, Professor Aleks Szczerbiak.
Okay, thank you very much. I'll try and crack on as much as I can because I realise I stand between you and lunch. So thank you very much for inviting me. It's a great pleasure to be at this conference, surrounded by people who are real transitional justice specialists. I'm not a transitional justice specialist. I'm a comparative political scientist who does most of their empirical work on Poland, and some people would say I'm not really a very good Polish specialist either, but so the way I come at this is somebody who's interested in looking at what the Polish case tells us about transitional justice and what transitional justice debate tells us about Poland. And my particular focus is going to be on a single country, and it's also going to be on a particular transitional justice method, which is lustration. Okay, and I take absolutely everything on board. The first speaker said about the need to look at all this holistically, that all these things are linked. But as a kind of research strategy, to kind of get at this, I've decided that I'm going to focus on the particular question of lustration. It's the most common form of transitional justice used in the post-communist states, and the one that's kind of dominated most of the public debates in a country like Poland. And the reason I'm interested in Poland, apart from the fact that obviously Poland's the most interesting country in the world about absolutely everything, is because Poland, I think, is a really interesting case of, in terms of the lustration debate, of lateness and recurrence. Okay, it's the archetypal case of introducing a lustration law late, and also of the issue continually recurring in Polish politics, just when it looked like it kind of had gone to bed, basically. So Poland, you know, as I'm sure you all know, as Timothy Gartnash, I think, alluded to in the first session, initially Poland adopted this kind of communist forgiving approach and an avoidance of the issue, exemplified by the Gruba Kreska, Mazowiecki's thick line approach, although a lot of people say this wasn't actually about dealing with the communist pastoral transitional justice, but it kind of became a metaphor for the approach of the early governments. And then the issue kind of recurs. There's various abortive attempts to introduce lustration in the kind of early to mid 1990s, and then eventually, kind of 8 years after the transition begun, Poland adopts a lustration law in 1997, and then a year later it adopts a law setting up the Institute of National Remembrance, a body that obviously has a number of functions, but one of which is to open up files to certain categories of people, that they can look at them, to people who are persecuted, or to journalists and historians. And I think the reason this is important is because I kind of lump lustration in with file access under the kind of the category of what might be called truth revelation procedures. It's quite interesting. Roman David looks at lustration as a personnel system. Well, I look at it as one aspect of what might be called truth revelation procedures. And therefore, in order to make sense of the issue of lustration, you also have to look at laws on file access, because they involve a large element of kind of DIY, do-it-yourself lustration, if you like. And then the issue comes up again in the early to mid-1990s as a lustration law passed in 2006, 2007. And of course, you know, it continues to recur. There are various episodes at various stages. So my core puzzle, the thing that I'm trying to work on at the moment, is, you know, why has this issue recurred? Why does it keep coming up? It's a project that I'm writing a monograph on. I'm about a year away from finishing it, so this is still sort of very much a work in progress. So obviously any observations are very gratefully received, but I've got, you know, some empirical material already on this, which is what I'm kind of basing my presentation on. So just let's look a moment at the academic literature. How have people who've kind of looked at this empirically and theoretically tried to deal with this puzzle of the recurrence of transitional justice, and specifically of lustration in post-communist states? Well, I suppose there are kind of two approaches to this, really, if I'm going to greatly simplify. And one of them is the idea of lustration, of changes of lustration trajectory being linked to what you might call elite strategic positioning. Okay, so it's about the idea of political elites using the issue instrumentally in order to get a strategic advantage. And I suppose the kind of extreme example of this is a book by Monika Nalepa called Skeletons in the Closet, where and Monika basically uses a kind of a rational choice game theoretical model which tries to kind of model the reasons why political elites might pursue lustration. And I was kind of in this camp a bit. I adopted what was called the politics of the present approach. It was originally pioneered by someone called Helga Welsh. But then I sort of started to kind of recant a little bit. And I started to read the work of other scholars, people like Cynthia Horn and Noel Calhoun and Hilary Apple, who basically view the phenomena in more kind of normative terms. Okay, in other words, they see it as a kind of more programmatic and normatively motivated debate. So in other words, it's not just about politicians sort of calculating what their advantage is, but they're kind of, you know, they actually believe in it. They're real kind of programmatic, normative motivations. So the way I tried to get at this is I looked at the debates on the 2006-2007 lustration law, right? And I looked at the arguments used by the supporters of the 2006-2007 lustration law. This is one of the kind of case studies that I've used. I looked at the parliamentary debates, I looked at the kind of the documents that were published, and I also looked at the media, the arguments used by sort of pro-lustration commentators. So what did I find? Well, the first thing I found was that the re-emergence of the issue became entwined with other debates as an element of kind of broader concerns about the need to improve the quality of post-communist democracy. In other words, it was bundled up with a kind of a broader critique of post-communist democratisation, a need to kind of deepen democracy. So the idea that people who hold public positions should be honourable people. The idea that democracy is threatened because these files exist and because somebody somewhere holds them and can use them to blackmail people in office. The idea that people kind of have a right to know, a key element of democracy is the right to know about the backgrounds of your political elites. The idea that there are links between the former communist security services and post-communist elites, economic, political and business elites, which were highlighted by various corruption scandals, to do with privatisation, the awarding of contracts, and the interfering in the legal process, things like the Rivin affair, the Orlen affair, as people would know. So there was an element of lustration being involved with a critique of democratisation and a need to deepen the democratisation progress. So that kind of suggests that there are kind of programmatic elements, at least in the justificatory discourses for this. But there are a number of kind of problems, caveats with this. One of them is that one of the biggest argument used in favour of the lustration law, the 2006-7 lustration law, was the failure of the existing model. Okay, it was the failure of the 97 lustration law. As Roman said, based on the idea of reconciliation, of amnesty for confession, and this wasn't adequately dealing with it because it set up a criminal procedure through which you had to prove people had lied, and therefore it wasn't really catching people. The idea that and this comes on to the idea raised by the first speaker, that the establishment of the Institute of National Remembrance by itself created an actor and processes which lead to the demand for further lustration. The best example of this is the so-called Wilstein list of 2005. But you create both an actor and both processes that have been pushing forward, have an interest and a belief in pushing forward for the with the lustration process. So, if you look at the statements that have been used, then there are certainly there's certainly sort of prima facie evidence that actually there are kind of programmatic motivations going on here. There's a kind of ideological narrative about the need for lustration to deepen the democratisation process, which is kind of pushing this, at least in terms of the kind of declared motivations of the speakers. And just finally, just to kind of to finish on a kind of normative note, and it's picking up on something that Jan Kubik mentioned yesterday in his lecture and came in the debate. I mean, the thing that the Polish case leads me to reflect on is the fact that the recurrence of transitional justice, the issues of lustration and file access is indicative, for some people at least, about a wider unease about the quality of post-communist democracy, does suggest some problems with the model of forgiving and forgetting as a model for new democracies. The roundtable negotiations, the pacting process, which is seen as a model of successful transition in the democratisation literature and as part of the justifying narrative of the founders of the Third Republic, is also created a sense among many Poles that nothing had really changed. And therefore the recurrence of that debate highlights the risks, if you like, of an elite bargain that appears to delay transitional justice and disenfranchises certain actors who might want to push forward with that from the process of regime change.
Okay. Thank you very much.